Buenas and Hafide, Todos Hamzu, Merry Christmas and Happy Holidays. This public hearing by the Committee on Federal and Foreign Affairs, Telecommunications, Technology, and Labor is hereby called to order. It is now 5:33 p.m. For the record and in accordance with Section 8107, Chapter 8, 5 GCA, public hearing notices were sent on Monday, December 16, 2019, adhering to the 5 working day notice, and a second public notice on Wednesday, December 18, 2019, 48 hours prior to today. In addition, this public hearing was noticed on the Guam Legislature's website at www.guamlegislature.org. We will proceed with some of the testimony that we've had folks sign in for today. I just want to note for the record that the pair of bills, thank you very much. The pair of bills that are on our agenda today are Bill number 200-35 COR, an act to amend subsection 9107B, 9109C20, 9110A and E, and 9115M of Chapter 9, Title 22, Guam Code Annotated, relative to updating Guam's 30-year-old rates for workers' compensation, as well as Bill number 201-35 COR, and an act to amend subsection 9141 of Chapter 9, Title 22, Guam Code Annotated, relative to the composition of the Workers' Compensation Commission. This is the second public hearing that we've had on these two bills. In our prior public hearing, we had representatives from the Department of Labor, from the Insurance Association of Guam, as well as the Guam Federation of Teachers, come and provide testimony for us, and that can be viewed on the legislature's website or on our YouTube channel. The pair of bills before us today represent two meaningful reforms to the workers' compensation portion of Guam law. This statute was enacted in 1989, which means that it's older than some members of our team here at the legislature. And indeed, portions of this statute have not been updated in more than 30 years. Given the importance of this lifeline and the considerable investment in capital and time paid by employers to employees, it's time to enact necessary changes to the workers' compensation law. One of the concerns we seek to address are the outdated compensation rates. These minimum and maximum payout amounts have not been updated since they were established. 31 years is a long time for rates to remain stagnant. We know that tax rates have not. We know insurance premiums have not. We know the cost of living has certainly not. Prices have risen since then by a lot. In 1988, a 50-pound bag of rice was $10. A 2-bedroom apartment in Tamuning was only $550 a month. Infant formula was less than $11 a case. I hope all of us in this room can agree that a compensation rate pegged to these prices must be adjusted to handle the increased cost, which, using the examples I just mentioned, range from 171 to 1,790% more today. For the record, the increases proposed in Bill 200 are based on changes in the Consumer Price Index since 1988. The methodology was put together by our team and validated by University of Guam faculty. I'm eager to hear from stakeholders present today and those who will submit testimony after this hearing as to the maximum and minimum rates you feel are fair and why. But perhaps just as important is the process in which workers' compensation claims are handled, challenged, and settled. The current processes can be unfair to both employee and employer, with old regulations resulting in delayed hearings. Retaining a lawyer for months on end can be cost prohibitive for worker and small business alike. And this is the driving force behind the reforms proposed in Bill 201-35. For the benefit of those watching at home, this legislation amends the composition of the Workers' Compensation Commission in order to conduct business more frequently and in a timely manner. We are proposing to remove appointees from the Mayor's Council, the Guam Medical Society, and Society of Certified Public Accountants, and replace them with members recommended by the Guam Board of Nurse Examiners, Guam Board of Medical Examiners, and the Guam chapter of the Society for Human Resource Management, or SHRM. At the Director of Labor's discretion, up to 2 members of the public will also join the board. Bill 201 also brings the commission into the 21st century by allowing for members to be legally present in meetings or hearings via telephone or video conference, and adds a requirement of electronic recording of meetings and hearings while eliminating a current mandate for stenographic recording. Based on feedback from stakeholders, I look forward to hearing requests to amend this measure's provisions on the makeup of the commission and perhaps other parts of the workers' compensation process that could be streamlined or modernized. I also want to thank the Guam chapter of SHRM for providing a technical correction to properly identify their organization for the recommendations they are proposed to provide. I know it can be difficult to put a human face on workers' compensation. Yet sometimes medical privacy rights constrain the debate, but there's also something to be said about injured employees not wanting to relive trauma, and certainly their advocates not wanting to put people they care for in risky positions. But one specific reason that I'm committed to seeing these reforms through dates back to when I was a staffer here in the legislature some 6 years ago. Through then Senator Tina Muña Barnes's office, I met Mr. Q, a GovGuam retiree whose workplace injury resulted in an amputation of his leg. He needed our help to navigate through the adjudication process and was in tremendous pain awaiting the fitting of a proper leg prosthesis. My husband is a firefighter and often finds himself and his team in harm's way. And so it was really hard to hear and even harder to see the suffering caused by a lack of movement in Mr. Q's filed workers' compensation claim. Thankfully, we were able to help, and Mr. Q did fly off to Hawaii to see a specialist. And his approved claim was also allowed for on-island follow-up visits to track the fit of his prosthesis. But unfortunately, there are too many Mr. Q's out there, suffering in physical and emotional pain, while this outdated law drowns them in red tape and unjust cap payouts based on an old cost of living. It's okay if we disagree on what exactly the best way forward looks like, and I'm willing to consider feedback that helps us make these reforms affordable and sustainable. But what isn't up for debate in my mind is the need to bring our workers' compensation law into the modern age, to have it reflect better the needs and realities that have changed since it was first enacted some 30 years ago. Let's work together to make it happen for our employers and employees, because it's time, because it's just, because it's right. Sidus Masi. And at this time, I'd like to call the panel of individuals who've signed up to testify. Please come forward when your name is called and be seated. Attorney John Bell and Mrs. Catherine Gale. Thank you very much for joining us this afternoon. And Mr. Bell, please feel free to begin.
Hi.
Thank you.
Good evening, Senator. Sorry, do I introduce myself at this point? Okay, sorry about that, I apologize. I was looking at the technical issues here. So briefly, I'm an attorney licensed here on Guam and also in California. I have a concentration in labor and employment law and some special training during law school in workers' compensation. I've also been working on workers' compensation cases right here on Guam for about 7 years. And so far, I've had a litigation against the Workers' Compensation Commission itself, unfortunately, in 3 cases so far that have successfully gotten the Workers' Compensation Commission to actually carry out the law, because otherwise they wouldn't. And so basically, not only to carry out the law as written, but to carry out the law as mandated by the Guam Supreme Court. So really, in a nutshell, I'm kind of boots on the ground. I'm wrestling. I've got probably a half a dozen workers' compensation cases right now, and because I've been working on this for so many years, people are coming to me all the time with a lot of the same problems. If you want me to, we're just introducing ourselves, or sorry, did you want me to go ahead with my comment at this time? So my comments are basically, now I've had the benefit of listening to this afternoon's hearing, and so I appreciate the fact that you do this very transparently. And so basically, one thing that I heard was that the commission wants more authority to issue penalties, which is great, but I kind of scratched my head. I thought I was surprised to hear that, because right now there's penalty provisions that the Workers' Compensation Commission chooses not to enforce. And so, perfect example, they're supposed to be giving $500 fines for people that are not insured, employers that are just not following the law. It's not even a discretionary. It says shall. The law reads shall, and yet the current commissioner the current workers' compensation administrator has very publicly and privately stated, both publicly and privately under oath, stated that they don't enforce that law. They don't find anyone, and so I think that's kind of a problem. I agree with the GFT's position today that the workers' compensation really should be about $1,000 a week. That would be a lot more fair. I'm not saying that I won't support the bill otherwise, but it's definitely something that would be more in line with what should be happening. I listened to the insurance representatives, Mr. Schnabel's, that he generally favors the bill, and shouldn't be a surprise, because that was my recollection of how all this went down. At some point, we had at least $700 a month, which was proposed. The insurance company, frankly, in my view, kind of watered things down. So of course they're happy, because this is what they picked, essentially. So I had heard about the moral hazard, or the concern about, what if we give people too much money, or what if we are allowing people to get up to $300, or a minimum of $330 per week. I think in my direct experience, frankly, the real moral hazard is insurance companies denying claims in bad faith. We're getting, I know that's not, the bill, one of the bills at least touches on that in terms of changing the makeup of the commission a little bit, but part of my response is that there's already provisions in place. It's already illegal to misrepresent the facts, and of course that works both ways. So there's already safety mechanisms in place to address that. As I understand the bill, nobody can earn 2/3 of what they were actually making anyway. I have done some quick math, and I guess it is true. I'm no math whiz here, but I guess if you do $330 a week is the minimum, that means that people working at minimum wage will get close to their full minimum wage if you do the math, right? $825 times 40. But I don't have a problem with this, and the reason is, for one thing, the people living on minimum wage, they don't have a cushion. If you're earning $825 an hour, you don't have a cushion to maintain those car payments, buy groceries, or pay your rent, frankly, if that's cut down to 2/3. There's no cushion at the bottom. I don't object to something that was said, which is a 6-month waiting period, or at least I think what the insurance industry was asking for is 6 months to a year. I don't have a problem with that. I'm certainly trying to be fair. What I will say, though, is beyond 6 months is reasonable. That's a compromise. But frankly, the insurance industry, knowing that, especially this is not a secret reform effort, right? No, this didn't sneak up on anyone. So anyone that's been writing insurance policies in the past year knew that this was coming, and so they should have addressed that within their contract. So I just object to anything more than 6 months. I've dealt with government contracts all the time, and that's something that the contractees essentially should contemplate when they're writing their agreements. I don't think it should be pawned off onto the workers. I promise you, Senator, I'm in decorum and in good faith. I'm not here to pick on any particular individuals, but as a matter of fact, the Workers' Compensation Commission is run, it's run by, the current administrator, Ms. Fullerton, and Mr. Pablo, who's the investigator. I saw the deputy referring to Mr. Pablo as my subject matter expert. Now, don't get me wrong, I'm sure that they've been doing this for a while, and they certainly know some things, and even some things that I don't. But this is one of the systemic problems that I talk about, is that you have Mr. Pablo, who, to my knowledge, has no background and has no legal, medical, or even workers' compensation background before taking this job. I know for a fact and from direct experience that Ms. Fullerton had, in fact, I deposed her and confirmed that she has no medical, legal, or workers' compensation background, at least before this job. And that's not to pick on them, it's only to point out the reality that who's running things, who's actually carrying out the system, and it's people that don't have this, quite the expertise, frankly. So this is a special concern because you have the director, and I'm not picking on this director or that director, just the way the law is written, the director carries out the law. I don't think this director, and frankly, to his credit, he's admitted it at times that, I don't do workers' comp for a living. So you have the directors that are not real familiar with the law, and then you have the day-to-day classified employees who, frankly, are not really that familiar with the law, at least medically or legally. And I think that's kind of why we have such a hard time getting the system done correctly. My suggestion, frankly, and maybe that's outside of the scope of this bill, but it's at least related, as an administrative law judge. An administrative law judge would be ideal because at least it would be an attorney that knows the law and knows to defer to experts where experts need to be deferred to. For example, the doctors. An attorney is not going to contradict a doctor, for example, typically. And of course, attorneys can be held to certain ethical standards that GovWA employees, as a matter of reality, usually aren't, just in general. Frankly, I've witnessed one horror story after the other. I won't get into the detail and be exhausted with that. But I do this because literally just one person after the other has come to me with pretty much the same horror story over and over about how they were denied due process, denied transparency with the system as it is now. And this is with multiple administrations now and multiple directors. Briefly, so a little bit of details with the bills themselves. My position, as I've stated, our people are not worth less than people in, say, Hawaii, California, New York. So they're getting closer to $800,000 a week caps. Our system is modeled off of New York. I don't see any real reason why it should be watered down to 500 some per week. Having said that, I'm support of this bill is if that's what's passable, so especially so long as we actually have a legitimate and transparent claims processing procedure, right? If they can actually get that, then I'm fine. At least in my view as an advocate. Regarding replacing one board member regarding replacing a mayor with a nurse, of course that makes sense to me. I don't have a strong position on getting rid of the CPA, but having an HR person makes sense. At least they understand basic labor and employment law, which often comes up, by the way. It often comes up, who's an employee, and that kind of thing. Giving the director the option to add 2 members of the general public, frankly, to me, that means replacing technically competent people with at least potentially political appointees and cronies that have no medical or legal knowledge at all. And so I do have a big problem with that, frankly. A quorum that excludes people with legal or medical knowledge to properly adjudicate the claims, in my view, is inherently problematic. Again, especially in light of who workers' compensation does have, a lack of legal and medical knowledge, frankly, is a major problem. We don't need more of the Wild West. We need competent and skilled people with medical, legal, and workers' compensation specific knowledge to be making the decisions within the confines of the law. That means the statute and the Guam Supreme Court's guidance in Fagan v. De La Sola. I'm not going to try to dazzle you with the legal brief here, but the real short version of what the Supreme Court held was that claims are presumed compensable until shown otherwise, so the burden's in favor of the claimant, number one. Number two, the burden's on the carrier, so the employer that wants to deny them. It's their burden to deny the claim. And then 3, don't be issuing decisions without due process and transparency. We shouldn't have to say this, but I swear the Supreme Court felt they had to say this. And that's still not being followed. And so I appreciate the indulgence here. I'm finishing up here. So basically, my advice is adopt administrative rules similar to how the CSC is, for example. The CSC, Civil Service Commission, has 4GCA Chapter 4, the public employees laws, and then they actually have rule books, right? They have a rule book that they adopt to basically actually carry out the commissions. Even the rules that are crystal clear are not followed. So I've really tried to just work with the Workers' Compensation Commission. They just don't follow the law, even when the law is very clear. So, for example, businesses are allowed to permit, if they get caught not having insurance, what happens to them? Nothing at all. They don't get fined. They actually have private meetings with the Workers' Compensation Commission, or at least the administrators, and then work out secret deals with no due process, oftentimes against the interests of the employees. And that shouldn't be happening at all.
Sorry, Mr. Bell, I'd just like to ask if you could, since they're not here to really
Sure.
defend themselves, if we could just stick to the nature of the bill.
No
that'd
problem,
be
no
helpful.
problem.
Thank you.
Absolutely. So, in fact, I was going to say that I didn't come here to sling any mud at anyone. I just feel that we shouldn't bury problems just because of concerns about people getting the wrong impression or feeling that they're being attacked. I totally respect that. I just feel that we shouldn't be burying problems either. Our people deserve better, and I do applaud you. In my view, what you're doing is literally extraordinary in the sense that, as you say, that's just the record. This hasn't been taken on in 31 years. So I absolutely applaud your efforts, and I appreciate it very much. And even the people that I may not agree with, I appreciate them in the sense that they are at least not trying to squash the bill. So at least there's that, if I can end on a positive note. Thank you.
Thank you very much, Mr. Bell. Ms. Gale?
Yes, Catherine Gale with the Employers Council. We just wanted to speak in terms of the actual bill, to update it, that it's great in that it's addressed something that has been outstanding for several years, and the amount is reasonable, and it's something that really addresses and it touches on all constituents, both the employees and the companies that they work for in the first place, providing them. So it's something that allows an adjustment, but at the same time is manageable and sustainable. So appreciate the work that went into that. Something that could work is wonderful. On the other side, in terms of the administration, looking at the commission, we note in terms of the efforts to bring on subject matter, which I think addresses a lot of the points that Mr. Bell was talking about, and that too is a great step in terms of allowing for what we feel probably the biggest challenge is the actual processing, is where a lot of people get held up. But looking at the members that were mentioned, of course, coming from the nurses, from the medical board, from Guam Bar, as well as from the Society for Human Resource Management, all excellent members to really understand the cases and hopefully work them through in an appropriate and proper manner. But we also note that you include a representative from the union, and if that individual from the union is included, then it would just seem logical to include a member from the employer side, so from one of perhaps the commercial organizations such as the Guam Chamber or GHRA or GCA, somebody in that fashion. And that's really just to understand, if we understand why subject matter experts are there, but then the inclusion of the purpose of the union, then we would think that it would be logical to include a representative from the business community and the employers for that. Just a little side thing, not having to do with my role as executive director of the Employers Council, but just as a member of a board here in the government, I notice in terms of membership, you're providing, $50 per session and then a limit of $100. Not that people really come on boards for any compensation. They're doing their civic duty. But this, probably like my other experience with the Civil Service Commission, is really a working board. And it sometimes can be like a second job, depending how busy it gets and in these cases, literally thousands of documents that the individuals will go through. So it might be something to consider why there has to be a limit. It just, again, while nobody's coming into it for compensation, that little bit extra helps in terms of reminding one why they're spending hours and hours doing something, which is great. It's for the civic good, but I do know sometimes that it's very challenging to get these types of boards filled and consistently, and that's just a concern, again, on the administration side, and would really like it to work well, and for the employees not to have this stumbling block of a board that can't fill quorum or get things done. So it's something to consider. And that's it.
I'd like to thank you very, very much, both of you, for joining us and for providing your feedback. And it's definitely something that I and the committee will continue to look at. It's my hope that we can get this bill on the floor as soon as possible. But I also just wanted to mention, we got some feedback from our legal team here, so I just want to thank our legal bureau here at the legislature for providing a review of Bill 201. The committee will be sure to incorporate the bureau's recommendations by amending the bill. And so we will amend the bill as recommended by legal by adding the commissioners before the word designee, so as to prevent potential ambiguity on page 1, line 6. We will also delete the term director and substitute it with commissioner to just maintain consistency. The term commissioner is used earlier in this section, and if the intent is to use the term director, the commissioner is also the director of the Department of Labor. So we just want to make sure that's clarified. That's on page 2, lines 14 and 16. We also want to revise language to identify the members of the commission, to state a, quote, member of the commission, close quote, to allow for instances when there is only one member who attends via telephone or video conference call, as well as when there are multiple members who attend via telephone or conference call. We also want to revise video communication conferencing to video teleconference, as that term appears in 5 GCA subsection 4312 on governing boards and commissions and the authorization of members to participate in regular and special meetings via video teleconferencing. That's also on page 2, lines 21 and 22. And then also add language to the proposed 22 GCA subsection 9141C, or amending 22 GCA subsection 9120, requiring such evidence to be transmitted to the commission within a specified time before the hearing, given that a member appearing by telephone may not be able to view and examine the evidence, such as documents that are presented at the hearing. And so those are some of the concerns that our legal bureau has addressed. So I just want to make sure that we're letting the public know. And if anybody has any additional testimony or concerns about that, feel free to give our office a call or submit that testimony to my office via email. Before I close, I just want to make mention that we did receive testimony from the Society for Human Resource Management in support of both of these bills, so we thank them for that. And then we also received testimony from Jerry Diaz, who is a local attorney, and I'll just read it into the record if you'll bear with me. December 23rd, 2019. Madam Chair and members of the committee, I submit this letter in support of Bill 200-35 COR and Bill 201-35. As a bit of background, I practiced as a workers' compensation defense attorney in California for 12 years prior to returning home to Guam in November of 2016. During my practice, the workers' compensation laws were constantly evolving to address the needs and concerns of not only the injured workers, but also of the employers and insurance carriers. These necessary changes were intended to provide a more effective system of benefits to ensure that the injured employees received timely and appropriate benefits while ensuring that insurance costs remain reasonable. Upon my return home, I was shocked to see that the weekly rate of compensation for disability benefits was capped at $250. and that it had remained at this rate since 1989. The disability payments that an injured worker receives while he or she is off work recovering from an injury is called temporary disability benefits. And these funds are meant to replace one's income while he or she recovers from the injury. Essentially, this means that a single wage earner who is out on medical disability is forced to live on $250 per week, which adds up to $500 biweekly or $1,000 monthly. The cost of living on Guam is quite high, and it continues to increase such that there is critical need to reform the current law for workers' compensation benefits. Further, it is quite unsettling that the rate of disability benefits has not been amended in the past 30 years despite the skyrocketing costs for basic necessities. To put all of this into perspective, the price of a gallon of gas has consistently remained over $4 for the past several years, and Guam Power Authority raised its rates in 2018. There is also potential for a rate increase proposed by Guam Waterworks Authority. All of these increases only solidify the fact that the current disability rate must conform to the changing times. Currently, the price of food is ridiculously high, and if an injured worker is also paying rent or a mortgage, there is absolutely no way that he or she can survive on $250 a week. Further, if the injured worker has a family to support, then the reality of not having sufficient funds to keep the lights on and the food on the table is compounded. So naturally, injured workers in this predicament will rush to return to work without the benefit of having completely healed from the injury, which may expose them to re-injury. There is a huge benefit in allowing an injured worker reasonable time to heal from an injury. From a physical standpoint, the possibility of re-injury is low. And from a mental perspective, the worker may be able to concentrate on performing the job instead of being distracted with continued pain or symptoms from the injury. The employer, on the other hand, benefits, as the return of an employee who has fully healed from an injury means they have someone who is physically capable of doing the job. To get to this point, however, we must ensure that the disability rates are sufficient and reasonable to allow the injured worker the appropriate time to heal so that he or she can return to being a productive member of our society. I wrote an article regarding this matter, and it was published in the July-August 2017 issue of the Guam Business Magazine. I've attached a copy of this article for your reference. Bill 200-35 COR seeks to increase the cap for compensation for disability to $520 per week, with a minimum rate of not less than $310 per week. It seeks to increase the total compensation of workers' compensation benefits, excluding medical services and supplies, to $206,570 instead of the current cap at $100,000. It also increases the compensation for serious permanent disfigurement and for death benefits. All of these changes to the existing law are reasonable and necessary to ensure that employees receive sufficient benefits while they recover from their injury. Bill 201-35 COR seeks to amend 22 GCA subsection 9141 to change the composition of the Workers' Compensation Commission to also include members from the Guam Board of Nurse Examiners instead of the Mayor's Council, a member from the human resource field instead of an accountant, and 2 members from the general public. By allowing these members to participate via video or teleconference, the Commission may proceed with its regularly scheduled meetings to address workers' compensation issues, such as disputes related to an injured worker's receipt of disability or medical benefits in a timely manner. For all of the aforementioned reasons, I support the changes proposed in Bill 200-35 and Bill 201-35. Sincerely, Jerry E. Diaz. And Jerry's testimony, as well as the SHRM testimony, and all the testimonies that have been provided today and received through my office will be available online as soon as our committee report is submitted. I'll be sure that that's up and that I inform everybody so that folks can take a look at all the testimony and make sure that we have enough time, that the senators have enough time to review it as well. But I really want to take the time to thank all of our stakeholders who've been a part of this process. John, you've really helped us to come along in this process ever since last term when I introduced this bill. So I'm really looking forward to getting it on the floor as quick as possible. I want to thank the Insurance Association of Guam. I want to thank SHRM, thank Department of Labor certainly for all the work that they've done to help us get to this point. And I think it's time. It's really time for us to do something about this. And the bills that come before us are only as good, really, as the information that we get from stakeholders and all the public participation and the testimonies. I really appreciate. I know it's a busy time of year, so I really appreciate all of your time today, and thank you so much for participating in this hearing. And with that, I want to wish you all a very Merry Christmas. And just thank you so much. Siduos maasi todas hamzu purifanatan mizu pagu. The Committee on Federal and Foreign Affairs, Technology, Telecommunications, and Labor hereby concludes this public hearing. Written testimonies may be submitted through email at Senator Biscoe Lee at guamlegislature.org or may be hand-delivered to our office here at the Guam Congress Building at 163 Chalan Santo Papa in Hagåtña until the close of business on Wednesday, January 8th, 2020. This public hearing is now adjourned. The time is 6:09 p.m. And again, we thank you very much. Merry Christmas and Happy New Year. Siduos maasi.